administrative justice. In the apartheid days, it was the only way you could fight back a little bit through the courts, trip up the government just here and there, using principles of administrative justice that had originally been developed by the judiciary under the common law in England, taken over by South African judges. And we used to use them sometimes in a defensive way. You've imposed a banning order on somebody, closing down the newspaper, restricting the person's movements. You haven't given them a hearing. It would work for a little while. The judge might say, no, you can't take away people's rights without giving them a hearing. Then Parliament would pass a law saying you can do it without a hearing. I know that happened to me. I was banned twice, and I wasn't given a hearing. I just received the notice. But we all became experts on administrative justice because Parliament was supreme. The courts couldn't challenge a law to say this is manifestly unjust, it's cruel, it's impossible, it's unfair, manifestly discriminatory, unequal. You couldn't do that. So we all became experts on administrative law. And an interesting feature was when the interim constitution was being created, there was a small technical committee working on it, and the two people responsible for the Bill of Rights were Hugh Corder and Lawrence du Plessis. Hugh was from UCT, Lawrence, I think, was then at Potchefstroom University. He moved to Stellenbosch. Both very, very good lawyers, thoughtful lawyers. And Hugh Corder's big thing was administrative justice. So he got a right to fair administrative justice into the interim constitution. Even although the agreement was nothing controversial, only general principles universally agreed upon will go into the interim constitution. Hugh and Lawrence got administrative justice in the interim constitution. They also got the right to non-discrimination on grounds of sexual orientation. I was delighted. It's so unfair to manifestly unjust to persecute people because they love whom they love. But it didn't fit in with the criteria of the interim constitution. Nevertheless, it was in there. In the final constitution, the administrative justice principles were even enlarged, and the administration had to be carried out, the administration of laws, in a way that affects the public in a manner that was reasonable and fair, and written justifications had to be given. That was actually built into the text of the Bill of Rights. Very, very comprehensive. The first case that we had, where we had to see what's the connection now between administrative justice and the Bill of Rights, was the famous SAFU case, South African Rugby Football Union case, where Louis Late, the president of the Rugby Football Union, felt that he was equal to the president, Nelson Mandela, of the nation. Not a guy to hold back, for better or for worse, Louis Late. And Mandela, President Mandela, is persuaded by the Minister of Sport then, Steve Tshweti, to set up a commission of inquiry into the management of rugby football in South Africa. I think some allegations on economic and allegations of preventing really open access of everybody to rugby. Louis Late's not happy. Goes to court, the High Court, the judge, very thoughtful judge from the old regime, hears his arguments and sets aside the commission of inquiry. on the grounds that Louis Late wasn't given, amongst other things, advance notice of the intention to set up the Commission of Inquiry, and the argument that the President hadn't applied his own mind to the matter, he'd simply rubber-stamped what Steve Twetti had said. The case is taken on appeal to the Constitutional Court. Now there's a big konkel and likabel. Louis Late's lawyers asked 5 of us to step down from the court on the basis that we're too friendly with Mandela. He'd gone into the witness box. He'd been disbelieved in polite language by the judge, and we were too close to him to be independent. We gave a reasonable suspicion of bias. Sure, very awkward. In my case, the allegation was that my wife and I had frequently had lunch with Mandela. I'd been divorced for I don't know how many years at that stage. I didn't have a wife. And I'd never had lunch privately with Mandela. But I don't want to say, have to say in court these things didn't happen. I got a little bit irritated. I was criticized by my colleagues for being a little bit narky with counsel. But we rejected that recusal argument. If we'd stepped down, there would have been no court left and the High Court judgment would have stood. It was actually, I'm going to put it very bluntly, a rubbish law by that judge, based on pre-constitutional principles. Now we had a Bill of Rights, fundamental rights. We didn't have it in the old days. The only way you could fight back was through these very technical arguments developed originally in England, then in South Africa. Now we had fundamental rights. That was the main protection given to ordinary people against abuse of power. But in addition, we had rights to reasonable administration, reasonable processes, and written reasons. But this was not administrative action in the ordinary way. This was the President exercising powers under the Constitution to set up a Commission of Inquiry. So completely out of court. You don't tell people, hey people, the public protector is going to investigate you, give you a moment to get rid of all the incriminating evidence. The public protector has a duty under the Act, when you're going to make findings, to give you a chance to respond to the findings. You don't have to give notice in advance. So that was the important point we made in the Safu case, is that it's now the Constitution that's in charge. The next big case also involved Mandela. It was the pharmaceuticals case, where he'd signed into law a New Medicines Act. No problem with the content, only he discovered that the Medicines Act abolished the schedule of dangerous drugs without replacing it with a new schedule. But he'd signed it into law. So he rushes to court and says, please withdraw my signature. And the judge says, well, it was a reasonable mistake. You were given wrong advice. It would create a chaotic situation where people can distribute heroin and dangerous drugs like that. It's now taken to us to decide. And we don't want to set aside the presidential signature because a mistake was made. You can't have rule of law when people can bring evidence, even the president himself. So we introduced the doctrine of rationality. In fact, what he was doing was not signing something into law, it was destroying law. And so it was an irrational thing for him to make a law that abolished control over dangerous drugs inadvertently. And so it was an irrational signature. But we also said we no longer look at administrative law as that separate sphere of law that operated under the old system, separate from the Constitution. There isn't a constitutional administrative law and a separate common law of administration. There's one single thing. It's all under the Constitution. So it meant now the court stopped using the old technical arguments that we'd used in the old days, that were used by Louis Late, and now look to the text of the Constitution. And we have PAJA, the Promotion of Administrative Justice Act, that lays down the principles and rules. It's often not easy. A terrible case we had, the New Clicks case, terrible in the sense we ended up with, I think, 1,000 pages of judgment, very divided court, very unpleasant procedural aspects involving Judge President John Schloppe in terms of not allowing a matter to go on appeal. It became very difficult, complicated for all sorts of unfortunate reasons. But we didn't end up with very clear judgment on that case. And the big issue was it permissible for the Department of Health to impose a cap on the price of medicines? Was that administrative action? Was it legislative action? How was it to be categorized? And the court divided. I know I had the swing vote, and I said in a case like that, the pricing for the first time should have involved the public, should have involved the profession. They should have been given a chance to comment on the regulations. Afterwards, if you wanted to move up or down, you didn't each time have to go back to the public. But it was all over the place, unfortunately. Today, PAJA is used very, very extensively. It's a very important protection for ordinary people in the country, of fair dealing in the application of the law. It's got a constitutional backing now. It's not dependent on the often very artificial rules developed in the previous regime. And it's a very, very important part of our democracy today. And there are many advocates, attorneys who specialize in administrative law. They do very good work. There's an extensive jurisprudence, but it doesn't play the role that it played in the earlier era, where it was the only way to challenge laws that were unfair. The main challenges to unfair law, to abusive conduct, comes through the Bill of Rights and through the fundamental rights that people have. And then one part of the Bill of Rights is the right to fair administrative action.
Is that correct?
Well, for what it's worth, in the New Clicks case, Albie Sachs, that's myself, introduced a principle of legality. Was the price cap on medicines, the declaration, I think it was promulgated in the Government Gazette, was that legislative action or administrative action? And I distinguished between the scale of the relationship between the people in government, how wide the impact would be, how individual it was. And traditionally, administrative law was for individuals, small groups. Once it becomes a more generalized provision, at least for the first time, I said there has to be public involvement and notice has to be given and could have been given in that case. But it was just one person. I think it got some support from Cora Hoekstra, Professor Hoekstra, brilliant academic dealing with administrative law. But I don't think it's a principle so well developed that it could be used, a principle of legality, to compel, for example, the master to provide the certificate. But in principle, if there were systemic failures, not just a failure for an individual, I could see that one could make out a case for, under rule of law, maybe rule of law principles, for getting some kind of interdict, some kind of injunction from the court. I can see a case could be made out for that approach. But again, that's something I'm very happy to leave to my colleagues to wrestle with on the bench at the moment. It's a dilemma. The more systemic and widespread failures of government are, the greater the need for intervention and change. On the other hand, it's getting the courts involved in institutional issues that shouldn't be the domain of the courts, should be left to civil society, public protest, public awareness, and the politically created institutions dealing with them. But the problem is when that's not happening.